All right, so again, every year the board has to undergo school ethics training. This is what we do every annual year. Basically, that requirement is set out in code. We know that the school ethics acts apply to the board members, school administrator, and managerial employees or officers. Again, there's two parts of the act. There's the act itself, and then there's the code of ethics. The act itself specifies very specific prohibited acts that board members are not permitted to undertake. Code of ethics basically gives you guidelines as to how you should act as a board member. We have been through the specifics before. Those are all in your packet. I'm not going to read through each of them, but I am going to focus on the code of ethics, on the upholding and enforcing of all laws, rules, and regulations of the State Board of Education and court orders pertaining to schools tonight. And that's because there's been a couple of cases that have come out that I think are warrant discussion. All right. Moving to the recognition provision that the board member should not take any private action that's going to compromise the board. Private action means any action outside of what the board member does as within their voting and within their role as a board member. Going down to the provide accurate information, we've had a case that came out recently that basically says that not only does a board member have the requirement to provide accurate information, you actually have the requirement to go and verify that the information you receive from outside sources is accurate, and you do that through your chain of command, which would be through your superintendent's office. You should do that prior to making statements relative to the information. Again, in terms of who can file a complaint, anyone can file a complaint. The Board of the Education cannot file a complaint, however, but individual board members can. There is a 6-month statute of limitations for filing of the complaints. I will tell you that the School Ethics Commission has been notorious of late of not relaxing that statute of limitations. This is the role of the School Ethics Commission. They act through advisory opinions and decisions. The advisory opinions we've discussed before as to who may ask for an opinion. They certainly are not ordinarily made public, but they may vote to publish certain opinions based on whether or not it's an issue that hasn't been examined previously. The thing about advisory opinions is that even though they are issued by the School Ethics Commission, they do not carry the weight of the law. So you can abide by an advisory opinion, be brought up on an ethics complaint, and be found to have violated the school ethics code or the act, even though you're acting in accordance with the advisory opinion. Those are your sanctions. What can occur? Since our last meeting that we reviewed this, there have been no recent advisory opinions published. That does not mean that they don't exist. It simply means that they have not been published. Remember, again, if you are questioning whether or not an action that you want to take is within that code of ethics, we can always ask for an advisory opinion. The only requirements is that if the board can certainly ask on your behalf, or a fellow board member can ask, as long as they notify the affected member that they are asking for the opinion. Some recent cases. This is a case where the respondent was the president of the Board of Education. Had made a statement relative to a political rival, that the person was a part of a radical group. The defense was that it was protected speech. There was a lot of discussion about whether or not radical group meant something other than a derogatory term. However, the School Ethics Commission came down. It was pretty clear. There's no disclaimer. You're going to violate the code of ethics. The disclaimer that is on there, and I think the board has been given one in case you want to publish. This is the one that the School of Ethics came down in May saying that this would be appropriate. for a disclaimer should you wish to use it. All right. Rose B. McDowell was basically a very small honorarium that the individual was receiving as the pastor of the church, voted on a motion to permit the church to use the school facilities. There was actually no money exchanged through that school use facility agreement. However, there was still a violation of the code that was found. And we're back to Facebook. You will see my disclaimer up there. I am utilizing the terms that were utilized in the original posting. The claimed violation here was basically anyone who espoused these views was incapable and could not be entrusted to make decisions on behalf of the educational welfare of students. However, the complainant did not cite a particular decision made by the respondent that was contrary to the educational welfare of the children. So without that nexus, that pulled the Facebook page to the role of the membership on the board, there was not a finding. So that nexus has to be present, and you do have to find a decision that was made that would be contrary to the educational welfare of the kids. Doherty involved a board member who had to call in to a meeting. They were reviewing the superintendent's evaluation. She sought to participate by phone. The remainder of the board voted to say no, we're not going to allow that because we could not guarantee confidentiality. She brought up ethics charges against her fellow board members. This is a really good case to talk about what the commission doesn't do. There were a number of missteps that the commission believed occurred, but because that is outside of their jurisdiction, they would not make any finding. Basically, the intent of this was that you, as a board, you guys monitor and proceed under your own rules, and you have the ability to enforce those rules. That does not preclude individuals from bringing an action under OPMA, an improper action in Superior Court to restrain that type of action, but things that are beyond the purview of the commission won't be heard in a school ethics decision. All right. The next two cases, again, if you receive messages, don't post them, don't repost them, don't send them to family members, don't put them on social media. It does have a way of making its way out into the public, and inevitably, the commission it's a very low standard to find whether or not it's injured someone, all right? The fact that you use a personal email account rather than a board email account does not matter. In this case, by the way, they upgraded this from the penalty to a censure. This was an individual who had no prior ethics issues, so it was a pretty big slap on the hand. They really wanted to make a statement as to what information should remain confidential. Don't be replying all to the full board and a community parent. This individual specifically addressed the parents' concerns and how he felt that the board should handle them. The superintendent in that district filed an ethics complaint. The ALJ found that even if the email contained confidential information, the superintendent had to prove that the disclosure needlessly injured another individual or the school. The commission in this case actually rejected the ALJ's legal conclusion and said basically by doing so you're undercutting the superintendent's authority in the chain of command. We're also going to do a quick HIB update just because these cases continue to change. We've had a big change this past year. This is the statute and the regulation. Again, your reporting requirements as a district board of education member, if you have witnessed an incident of HIB or you have reliable information, you must report that incident. We have the definition of an HIB. What is different in the last year and a half is that there's a series of cases that came down that said intent is not required. And this is a big issue because, quite frankly, there's cases out there that talk about, unintentional consequences, and it has to be within a reasonable person's standard. So this was a big deal, particularly in this one. This case involved a teacher's recommendation to a student with a 504 plan. It said she didn't think it was a good idea for that individual to enroll in an AP chemistry class, but left the decision up to the student. Key factors were the course difficulty and the student's prior performance in the honors chemistry class. The student believed that that was a statement about their disability and their anxiety and inability to handle classes. The board substantiated the HIB, although it was unintentional. The ALJ rejected that, and the commissioner came back and said, no, intent is no longer required. So it's a word of caution about what is going to be perceived as an HIB. This is, again, another case where intent didn't matter, and this is one of the cases where the defense is we're joking around, we're kidding around with each other, we don't take this seriously. This is the way we speak to each other. Again, intent is not required, and they'll find that. So that you guys do not feel like you are the only ones that face this issue. This is a case that has happened across the school districts relative to the use of very racially charged language. This actually focused on whether or not the kid actually said that, but again, the use of that word was insulting and demeaning, regardless of the intent. So the commissioner upheld the HIB. I included this case, you'll remember, this is the Township of Jefferson case. It was a bunch of 5th grade girls online utilizing that term. It was figured out, everybody was pranking. The board said they were mutually engaged in conflict. There is no HIB. The ALJ, the commissioner, and the active upheld the Board of Ed decision. And I've highlighted the date because if we go back here to July of 2020, where intent is not required, we now have a higher court saying that intention does matter. So we're going to be watching to see the next round of cases that get up to the active on this case. That is my presentation for the evening. If anybody has any questions, I'm happy to answer them.